Following a series of highly publicized scandals in the 80s, PMC was created to help restore citizens' faith in the courts and increase the overall integrity of the state judicial system. Today we're here with our wonderful hosts that are working with us to help us educate the Commonwealth. We host multiple workshops all across Pennsylvania, and today we're going to be talking about how to administer an estate. Three of our libraries that are co-hosting with us are Jefferson Hills Public Library, and Jane Milner is with us today. Also from the Mount Lebanon, Eric Meisenberg, who's the Public Service Library, he's with us as well. And then we also have Kaylee Hordat, who's the Adult Program Coordinator here at the Pleasant Hills Library. Katie, you want to come and say hello? Or?
Hi, everyone. I'm the Adult Coordinator here. I just want to thank Michelle and Carl for coming out here and presenting this today, and for reaching out to the library and seeing if we could do this. And I think it's excellent that we were able to come together with several other libraries to really make sure that we reached out to as many people as we can to educate people about this. So thank you guys very much. I really appreciate it. And thank you all for joining today too. Thank you.
Wonderful. Now I'd like to introduce our speaker, Carl, who is Carl Zacharia. Zacharia. I apologize.
No.
Oh.
Let's look at screen test. Is Jenny Ramalli?
Oh, that's somebody that's on the.
Yeah, but it's showing up to click off of it.
Oh, okay.
Okay.
There you go.
Oh,
Carl.
we need to mark the screen share. Okay, I gotcha. Perfect.
Good?
Yeah.
Sorry, guys. Just give me 1 second to figure out the screen share again. Oh, right here. Okay. Should be all good.
Okay. Well, I've never done this before. And when I say never done this, I've never done a Zoom and in person at the same time. So this is my first. Thank you for attending online and in person. My name's Carl Zacharia. I grew up in Elizabeth, not too far from here. I live in Peters Township now. I spent a couple years down in Florida, but by and large, I'm from Pittsburgh, born and raised always. W&J College and Duquesne Law School. In fact, I went to school with Roger Goodell. He's our most famous alumni now. Roger is a year older than I was. But I'm pleased to meet you. I'm the founder of Zacharia Brown, with an office in Versaillesboro, McKeesport, that way. Then one in McMurray, that way. One in Wexford, that way. And a couple in Florida, too, but we won't talk about that. I'm here to talk to you about how to administer the estate, probate as it's called. And I have a lot of information to give you. Let's see, is this going to work for me? Page down. That push down. Let's go over here and hit the button.
Yeah, I can do it. It's okay. I can do it. I don't know why it's not working on some.
That's right. Okay, so one more. I'm licensed in Pennsylvania and Florida since '93 and '94. Boy, it doesn't seem like 30 years now. You get older, a couple days ago, they haven't the past 15 years, right? Okay, so it's called estate administration. It's also called probate, which is Latin. It means to prove the will. These are administered in Pennsylvania at the Register of Wills. The Register of Wills, or ROW as they call it, is in every county except for two. Allegheny County and Philadelphia both have their own court systems. It's called the Department of Court Records in both of those counties. So in Allegheny County here, I still call it the Register of Wills, but technically it's the Department of Court Records. And they're the ones that handle all estate matters, guardianship matters, probate matters. And probate, again, is the process of filing the will and administering somebody's estate after they pass away. I do want to tell you that it is somebody's estate is way more complicated than it seems. Because your will doesn't handle really all that much. I mean, it does, but for the most part, people's largest asset today is their IRA. IRAs have beneficiaries on them, not probate, doesn't go through the will. Still has to be administered, still has to go to the people it's intended to. They still have to pay taxes on it. But it's your IRAs don't go through your will, nor does life insurance, nor do annuities, nor do TOD accounts, nor joint accounts. But you still need someone to handle all of that because it can get awfully confusing to determine who is going to pay the expenses of the estate, the funeral and all that, who's going to pay the taxes. The will almost always covers the house. So that's always the big one that's covered. How much time is overtime? Did that work? Does that work? Okay. So, as I was just saying, do you need to probate the will? Well, if you answer no to these, if they had no property, of course, there's nothing to probate. You do not have to file the will in Pennsylvania when somebody dies. You have to file the will when you open the estate. Otherwise, you don't have to file it. And a will does not get recorded or filed when you do one while you're alive. A lot of people think that's the case. It is the case, I believe, in Ohio, but it's not the case in Pennsylvania. The only time you file that will is when you are ready to probate that estate. And when you file that will, there's lots of obligations that come with it. When you open the estate, I'm jumping ahead. Let me get through this first here. But did you have any joint property? Yes. If it's all joint, you don't have to probate it. You have beneficiary designation, don't have to probate it. But if you have anything that is just that person's name alone, usually that's the house, it's an investment account that has no beneficiaries on it, a sole owned checking account, bank account, those all have to be probated. Those go through the will. What else goes through the will? If you have an IRA and no beneficiaries on it, life insurance, no beneficiaries. The will catches everything. It is the default. Do you need a lawyer to probate an estate? Now, how many of you think I'm going to say no to that? Obviously, I'm a lawyer. Sometimes it might be the case, but it's going to be very simple. There's a lot more to this than people think. It's not terribly complicated. It's just not. But there's a lot of nuances. I had one today where they said, "No, we really don't have to do anything further." When they sold the house, they took care of the taxes. I said, "What do you mean they took care of this?" They paid all the inheritance taxes. It's right on the closing statement. Well, she didn't know any better. That wasn't a payment of the inheritance taxes. That was an escrow of the inheritance taxes. The closing company of the sale, the real estate had to escrow that money until they got proof positive that the taxes were paid and the state was happy with the return that they filed. This is a lot of things like that in this whole process. But it's not a legal requirement to have a lawyer. It's I think important to have a lawyer and to have somebody that knows what's going on. They do have neighborhood legal services that will provide some assistance to you. But if you decide not to hire a lawyer, you are assuming some personal responsibility, and it can. Some people just find it terribly frazzling, nerve-wracking to go through this process. Whereas to me, it's what I do every day, so it's pretty simple. But for some people, they find it very nerve-wracking. Okay, okay. I am a lawyer, as I said. This is just a little disclaimer. Nobody here or here can take anything I say, please, and say, "But you said that I could do this, and it didn't work." No attorney-client relationship, merely because I'm talking to you live or on Zoom here, okay? Every lawyer has to do that. It's not to be easy, it can be, but there is personal liability if you're not really, really careful and know everything that you're doing. I'm going to touch upon a few of those. And here they are. Payment of creditors. I get this one pretty often. My client, we've opened the estate, they got some money in the account and they start paying the bills. Don't pay the bills. You cannot pay the bills until we make sure there's enough money to handle all the creditors. There is an order of priority on who gets paid first. The costs of administering the estate are first. The funeral is way up there. The medical bills in the past 6 months before the person passed away. Medicaid. Lots of people on Medicaid nowadays, in nursing homes and so forth. That they have to be notified. You have to pay out their claim. Those are all ahead of credit card bills. Credit card bills are at the bottom, so you have to make sure that you don't pay the wrong bills and run out of money, because you're liable personally for paying the rest of them if you don't. So that's one little area to be careful about. You have to make sure that the people allocate their the taxes and the expenses. If you have a will right now, I would invite you to take a look at your will. And look at that section that has to do with the payment of taxes and expenses. What does your will say about the payment? This is my pet peeve. Many wills have boilerplate language in there that says, my probate estate, the residuary. Now, the residuary in your will is where you say, everything else I have goes to these people equally. Like everything else is left. It says, the residuary shall be responsible for paying all the expenses and all the taxes associated with my death. But what if you have a will situation, or excuse me, an estate situation, where you have your children get your house, your significant other, boyfriend, girlfriend, or whatever, the deceased person, they get this money over here, or maybe they get the house and your children get the money. And then when you pass away, this has happened to a case I had not too long ago, where the will said that, and the girlfriend of the guy that passed away owned the house together with the gentleman that passed away. There was a mortgage on that, and there was inheritance taxes on that house. Like a $400,000 house and like a $200,000 mortgage. The children got the $300,000. Well, the brother of the lady was a lawyer, and he made a request to the estate. Said, "Well, under PA law, the estate is responsible for paying all the taxes and the expenses associated. So we expect you to pay all the death taxes, which would have been in that rate 15% of a couple $100,000 plus the mortgage. There wasn't enough money left for the kids. That's the way the will read. You got to be very careful with this stuff. That's my pet peeve is look at your will and make sure it doesn't say that, especially if you have a complicated situation like this. The way I like to write it is, whatever the people get, they pay their own taxes. They're responsible for their own taxes from whatever source the money comes from. Okay? There's a couple of different types of estates. One's called a testate. Testate means there's a will. You died. Testate, that means you had a will. You have an executor named in the will. That will, how many, I can't really ask you all. If you have a handwritten will signed by the deceased person, this is my will, I leave everything equally to my children, and my oldest son, Brian, is the executor, signed and dated. Is that good? Is that a will? It is good. That will. Now, it takes a little bit of work to prove that. You have to bring people into the courthouse, say, I know his signature, that's it. They have to sign oath to that extent, but that will work. It's not recommended. If the will is notarized, and there's two witnesses, it's good to go. So that's testate, that's the will. Intestate means without a will. So when someone dies without a will, every state has these. It's called intestate, and this whole determination of who gets what. I actually do a lot of it. There's a lot of people that don't have a will. Sometimes it's problematic. I have a case where a person passed away, didn't have a will. He had a lot of businesses. His businesses were buildings. It was about $20 million worth. And he had a wife and 4 kids. No will, didn't have time for a will. So when he died under intestate proceedings in Pennsylvania, his wife got the first $30,000 off the top. And then the wife and the children split everything equally, 50-50. That sounds okay, doesn't it? Except there's this thing called inheritance taxes. And the inheritance taxes between husband and wife is 0. There's no inheritance tax. Between parent and child, or parent and grandchildren, it's 4.5%. So the wife gets the first $30,000. The wife and the children split everything 50-50. So she would get 30,000 plus 50%, and the 4 kids have to split the other 50%. Maybe $10 million in buildings. Anybody can tell me what 4.5% of $10 million is? They have to come up with that tax money. $450,000, I think. They got that kind of money. It's all real estate. But it would have been a pretty good idea to have a will for that person. But he didn't. Lots of people don't. But that would have been super important. Lots of businesses, lots of real estate, completely illiquid. And if you don't have a spouse, if you have just your children, it goes to your children. If you don't have children or a spouse, it's your parents first, assuming no grandchildren. Then it's your parents, and then on down the line. Florida's is very similar. I had a case about 10 years ago in Miami where an 89-year-old man passed away, never married, no children, no brothers or sisters, and no will. So who were his, and of course his parents were passed away as well. So who were his heirs? I guess kind of dicey. He didn't have a will, just had a will. His heirs were 50% of his father's heirs, and 50% to his father's brothers and sisters, and 50% to his mother's brothers and sisters. So we had to track down the family tree, and all these people came up with 87 different people at different levels who were to inherit. Would have been a good idea to just have a will. But that's what intestate means. And then there's other parts, things that make up the estate. It's not just the will, as I said earlier. You have assets with beneficiary designations, IRAs, life insurance, annuities. You have assets that are owned jointly by one or more people with you. And you have your probate estate. You have specific gifts, and then that residuary that I mentioned. You know, a lot of people want to say, and I'm talking more about wills, I think, than I am about probate, but it's all part and parcel to it. A lot of people put in their will, well, I'll leave each one of my grandchildren $10,000, and then the rest will go equally to my kids. Well, those are called specific gifts, those $10,000 gifts. Might not be what you intended, because if that person ends up in a nursing home or in long-term care and really runs out of money, and say they have 10 grandchildren, those 10 grandchildren are getting that $100,000 off the top. And then their children have to split what's left. And there might not be much left after that. It depends on the wealth of the person. That might not be what they intended. Sometimes the percentage is better, or you could say the lower of $10,000 or 5%, whichever is less. That way it's kind of capped at that amount, no more, and not eating up the entire estate. When you hear the word gifts, it's just a little legal thing. A devise is a gift or a transfer of real estate. I don't know why they call it a devise. It's called a devise, not device, devise. And a bequest is cash and financial things and other things of that nature. Okay, probate basics. Who the executor is a person you name. If you don't name one that's intestate, the heirs have to get together and choose somebody to be the equivalent of the executor, called the administrator. And that person's job is to gather all the documents. They're basically in charge. Now, because they're in charge, it does not mean that they have full run to do whatever they wish. They're held to a particular duty. They've got to act in the best interest of the estate. They've got to do what's best for everybody that's involved, all the heirs. That's called a fiduciary duty. They've got to gather up all get the death certificate. They've got to gather up all the paperwork for the estate, the petition, the estate information sheet in some places, pay the probate fee, get their short certificates. They got to go to the register of wills to get sworn in. And it can happen anytime after the person dies. The faster the better. There are, again, inheritance taxes in this state. And if you make a payment on the inheritance taxes within the first 90 days, you get a 5% discount on the overall inheritance tax bill. But all taxes are due within 9 months of date of death. Okay, the steps. The first thing is, after the completion of the forms, you go down and you file the will, the original will. You gotta have the original. If it's not notarized, you have to bring in witnesses or get affidavits. I won't go too much into all that. You have to have the death certificate. You have to have the filing fee, which is usually several $100s. In just about every county, about several $100s. And then you go to the register of the will and you get sworn in, and they're going to ask you, how many short certificates do you want? If I'm talking so fast, too fast, someone tell me to slow it down because I always talk too fast. They ask you, how many short certificates do you want? A short certificate is known in other jurisdictions, in other states, as letters. It's a piece of paper from the court that says, this person is the sworn in executor of the estate. We call them short certificates in Pennsylvania. They're not short. They're one page, but they used to have a binder, like a perforated binder, and they'd write on the top what numbers and who it went to, and then they'd tear it off. So instead of it being 8.5 by 11, it'd be 8.5 by like 9, and that's why they're called short certificates. People call our office often, and they said, my dad died, and we went to the bank, and they told us we had to get a short certificate, and then you can get one for us. Can you get us a short certificate? It's that means you are opening a probate estate with a whole bunch of legal obligations once you do that. It's not that simple. Just to go get a certificate, say, here you go. In some states, the executor is called the personal representative. Okay? The estate information sheet, we don't really use this in Allegheny County or Washington County or Westmoreland County where I do business. Not anymore, but other counties still do it. Some of them require it, but not the ones around this area. Well, there's this petition for a grant of letters. It's 2 pages, and you got to fill out these parts that says what's the person's name, what was their will, if they had one, if they didn't, who's the named administrator, who are all the heirs. All this information to fill out in these 2 sheets. And it's not really all that bad, not all that complicated. And these forms are online. If you go to AlleghenyCourts.pa, I think it is, just Google it. They're all in Allegheny County's website or pacourts.us/forum/for the public, so forth. Google it. Forum/for the public, so forth. That's a little Sir Echo.
Yeah.
That's okay. Oh, well, it's come across okay. Okay, and again, the letters testamentary, that's what the short certificate's called. They're either letters of administration or letters testamentary. That tells the people that there is a will or there is not a will. Now that person has been sworn in, they have their short certificates. You take a short certificate, a death certificate, and you also have to get an EIN number. You get that online from the IRS. It's an employer identification number. Even though you're not going to have any employers, you have to get one of these. It is for the payment of income taxes, for the charging of income taxes by the various organizations like banks and investment companies. When somebody dies, their Social Security number dies too. So they don't. If their bank account brings in dividends or interest, they can't charge the interest to that Social Security number. They charge it to the EIN. That is the taxpayer ID number for the estate. So you start gathering the assets, go to the banks, and you gather money. Maybe you open up an estate account, and now comes that part of paying the bills and so forth. And that's where it can get a little bit tricky. Again, you get sworn in. You after you get sworn in, you also have to give notice to all the beneficiaries. You have to send out this letter called Notice of Beneficial Interest. Again, it's a form. It's available online. It's called Notice of Beneficial Interest, and you have to send one to every heir. And if there's any heirs that are intestate, like if somebody died, they left everything to their friend, and they have 3 children, you have to notify those children as well, even though they're not included, because the will leaves them out. So you have to give all these people notice. Then you have to tell the court, I gave notice to all these people. It's called a certification of notice. It's on here somewhere. No, certified notice right there. The state's going to advertise in 2 papers, the Pittsburgh Legal Journal or a paper of general circulation in your area, and the county's legal journal. You ever see these little ads, little square boxes, the classified ads? Do you know why they do that advertising? The reason we do this advertising for estates is to shorten the life of any creditor claims. So if the deceased person had owed money to anybody, there's a 4-year statute of limitations on a contract claim, which would be credit card bills or contracts for that sort. That's a long time to keep an estate open for 4 years. So we advertise the estate. It runs once a week for 3 weeks. 1 year from the time that third ad runs is the end of the statute of limitations. And anybody who claims the deceased person owed them money has to file a one-sheet page called a statement of claim. The deceased person owed me this much money for this. Boom, they file that, they now have a claim. And their claim has to be dealt with before you can close the estate. That is why you advertise. The EIN number I mentioned, you get that. Now you get start gathering all the assets together. You get an estate account, put all the money into the estate account that you get. You look at all the debts and you prioritize. Administrative costs are first, funeral second. There's something called a family exemption. If you have a child or family member that lives with the deceased person, that's $3,500 you can take off to give to them. Medical bills and Medicaid claims. And then down the road to the last one are credit cards and any unsecured creditors. Okay. After that, you have to file an estate inventory. An estate inventory is listing of his probate assets. The man had a house, an IRA, and an annuity. Probably the only asset going on that inventory is the house. It's the only one that's probate, whether true or not. And then you have file their tax returns. The income tax for the deceased person for that last year. And you always don't have to file a federal income tax for everybody. There's a certain minimum amount of income the person must have before you file an income tax return for somebody. I don't know if you knew that or not, but not everybody files those. You have to file a Pennsylvania inheritance tax return. These are all things that the lawyers do. If you're really, really fortunate, you have to file a federal estate tax return. And I'm jokingly saying that because this year, you do not have to file a federal estate tax return unless the estate was worth over $12 million. So if you're fortunate enough to have more than $12 million, you file that return. And in the end, the estate may have its own income through a lot of investments, a lot of interest, a lot of dividends that come in. Then you have to file a Form 1041, which is an income tax return for the estate. And everybody who inherited from the estate, from the residuary of the estate, gets a portion of that income taxable to them to use on their income tax return for the next year. Once you've done all that, there's two options to close the estate after you've distributed everything. I should touch upon it. Distribution is something you have to be very careful with. If you are going to be distributing money to the heirs who are inheriting, you have to be very careful on how you do that. It can be a difficult proposition. Once they get their money, a lot of times they start questioning, well, what about this? What about that? You're charging a lot of money for your executor fees and blah, 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 blah. You gotta be careful on how you do it. You want to get their signature on an agreement saying, this is what we had. This is an informal accounting. This is what came in. This is what we spent our money on. This is what's left, and here's how it's being divided pursuant to the terms of the will, which is attached. I normally have them sign that agreement before they get the large bulk of their money, because otherwise they may just try to hold your feet to the fire and say, I'm not signing. And if they don't sign, you still have an answer to that. But now you're going to court. For the first time, you're going to court. It's called going to audit. It's a formal accounting of the estate. It's about 10, 12 pages long, sometimes longer. A listing of all the assets that came in, all the debts that were paid, all the income that came in, the expenses, distributions, proposed distributions. This is a long, super convoluted thing that I try to avoid at all costs. It's a lot more money to do all that. But they could make You do that if you're not careful. So once you get that family agreement signed, or you go through your form of account, now you can distribute the assets and close the estate. A lot of people think that probate takes such a long time. Oh, it just takes forever to go through probate. You know, it takes years. No, it doesn't. You all heard this, you know, in the paper or on TV, and Susie Orman, and oh, it's a long time. It's overseen by a judge. No, it's not. Not in Pennsylvania. It is in Florida. Florida's a whole different animal. Florida, I'll just tell you a little bit about Florida. Most people have a revocable trust in Florida because probate in Florida can be a real walk in the park, and that park is Central Park, and it's midnight. Okay, it can be a tough process. You have to put together the petition, and the judge reviews it before they sign it. Say, well, I had one once. This man lived in Newcastle. He had a nice estate, about $8 million. He's a pretty good sized estate. And he never got married, but his girlfriend for 30 years, she had been a widow. He met her when she was a widow. And she had 5 children, and those children were his children. He named the oldest son as the executor of the will and left everything to them. This is in Sarasota County, Florida. The judge looked at it and said, he's not a resident of Florida. He is not blood related to the deceased person. He can't be executor. That was a rule I hadn't heard before, so I looked it up, and there it was. Staring me right in the face. Let's all waive it. Everybody sign off and say, we saw that law. We'll waive it. We trust it. We'll waive it. The judge said, no waiving it. He says, you can't even postpone. Get somebody else. Get somebody down here. So I have a friend, a Florida lawyer friend of Florida. We hired him to do the estate. Because that's the way Florida is. It's judicial. Takes a long time. They're requiring an affidavit of no criminal history of the executor in many counties. It's tough. And they use trust. But it's also tough right in Pennsylvania. Okay? I jump around a lot. I say, notice of beneficiaries. I already told you this. It's after you open up the estate. What I do, as soon as I open up the estate, I get the EIN number, and then I send out the notices to everybody. And I send a certification notice. I sent the notice out to everybody. And these are just forms. Right here that you can see that the first one says notice of the state administration pursuant to rule blah, blah, blah. And the second one is certification notice. The first one goes to the heirs. The second one goes to the court saying you have notified everybody. And when you send out this first, notice, many of the people you send it to are going to call you and say, what the heck is this? It's supposed to say that you're an heir in the estate and you have some benefit from it. Now, if you look at it, that's what it says, but there's always a lot of legalisms in there. But that's what it is. They say, hey, you're the heir to the estate, we're giving you notice. By the way, if you have an heir, a child that you want to disinherit, which is not uncommon, I would recommend that you reference them in the will as somebody that you acknowledge their existence, and for personal reasons, you're not leaving them anything. Because if you do, if I leave my daughter $1, guess what? You have to send her a notice of beneficial interest. She's involved in everything. You merely state, I know she's there, I know she's my daughter, I'm not leaving her anything, then she's not part of the estate. She's not included. She's not an heir. All right, I talked about the advertising. Again, general circulation, Pittsburgh Legal Journal or the Westmoreland County Legal Journal runs once a week for 3 weeks to cut back that statute of limitations. 1 year. I talked about all this already. So you just identify all the assets, close them, gather them all together, file that inventory. Again, it's for probate assets only. So no IRA would go on there. Unless, the IRA would go on there if there was no living beneficiary, or if there's no beneficiaries at all. If the will catches everything, it's the default, and that would be probate. That's going to be filed within 9 months. The same form used everywhere. And then comes our inheritance taxes. So these are our rates. There is no tax between spouses. There is no taxes to 501c3 charities. If it is a direct descendant or an ancestor of yours, the descendant would be your children or your grandchildren. The ancestor would be your parents or grandparents. It's 4.5%. Lineal relatives. If it's to your brothers or sisters, it's 12%. If it's to anybody else, it's 15%. Now, I don't know if I included it here or not. There is a lot of little tricks that the lawyers know about. They're not tricks, but a lot of things you can do that the lawyers know about. I mentioned to you the $20 million estate where it's going, you know, half to the wife and half to the children, and that huge problem facing them. There's something called a disclaimer where you can disclaim things which says, I don't want that. Give it to, in this case, the children are disclaiming and giving the money to their parents. They let my parent have it all. That way there's no taxes. There's no inheritance taxes. So that's how we moved from 4.5% or $450,000 up to zero by doing that. 20 million sounds like a lot, but it's all in real estate. There's no cash. There's not that kind of cash to pay. And this number 5 down here, it's kind of an important one. If you inherit an IRA, which I've mentioned many times, the IRA still owes income taxes. So you're going to pay inheritance taxes. And when you inherit that IRA, you now owe the income taxes on it. So that's a little double whammy there. And if they're worth over $12 million, you might be paying estate taxes too. A triple header. So lots of taxes. IRAs are particularly hit on tax. It's called income in respect of the state. That, you know, the person that owned it never paid taxes on that money to begin with. So now that you're getting it, you have to pay those taxes within 10 years. That's a new rule. It's called the Secure Act. So if you inherit an IRA, you have to pay. Most people, there's a couple of exceptions, and it's a class all by itself, called the Secure Act. And for most people, if you inherit an IRA, you've got to take all the money out and pay the income taxes within 10 years. Roth has no taxes. No income taxes on Roth. No. Inheritance taxes, yes, that's still there. But no, Roth does not have income taxes. That's the person pays the tax at the beginning, unlike an IRA where they pay those taxes up front. All right, I mentioned this one earlier. This is really a big one. This is that priority. The administrative expenses. That is the cost of opening the estate, the fee of the executor, and the lawyer fee. Those are all #1 expenses. The second one is that family exemption. If there's a family member that lived in the household with the deceased person, they can take $3,500 off the top for continued living expenses off the top. That be? Then we have the funeral burial expenses. This is the big one. Too many people don't know about this. Medicaid. The law says that you have to get, if there's a Medicaid claim out there, you have to get clearance from the Department of Human Services that there is no Medicaid claim. And the law also says if you don't do it, if the executor does not collect Medicaid's money and they distribute the money without paying Medicaid, the state, they're personally liable. Personally liable, personally on the hook for paying the state that money, which can be a lot. Craig Barker, the rent of the deceased, I can never remember this one. All other claims by the Commonwealth, and then all the other claims of everybody else. Most of them fall into, credit cards all fall into the last level. You also find out that if it's not a big wealthy estate, a lot of the credit card companies will start coming at you right away with their claims. They'll want to cut deals right away. The way you owe us $4,000, if you pay us now, we'll take $3,000. That's how. Do they know? what do you do if you're owed money and someone passes away? You got to file that statement of claim. But how do you actually get paid? You might have to go to court to get it. They know that. And lawyers going to court is way more expensive than lawyers doing a probate or anything else. Anytime it involves court, it's expensive. I had a case once. It actually got published. This case got published as law in this country, and it was called case law, where a gentleman passed away. It's around the year somewhere in the 2000s, early 2000s, and his brother stepped up and filed a claim and said, "I loaned him $15,000 in 1982. He's not paid it back." He filed a claim, and we said, "We're not paying that. We're calling BS on that one. That's a legitimate claim." We didn't actually put we're calling BS on the legal, but that's what it was. I thought, and my client thought too. So he pushed us, and so we're not paying it. So we had to go to court. We wanted the estate one. It's way too old, and he took us up to Superior Court. We were arguing again, and there is such a thing as limitations from '82 to 2007 or whatever it was. Is just way too long to not get your money back or reinstate it. So reinstate your claim. Okay, the distribution of the assets. The executor or administrator can pay what's called a commission. It is usually a percentage of the estate. If the executor takes a commission, it is income. It's earned income, and you report it, and you pay income tax on it. Usually a percentage of the estate. Every estate's different. Most executors don't take a commission, but some do. None of the assets are distributed under the terms of the will or according to intestate law. If you're transferring real estate, again, real estate can be just in the deceased person's name alone. If there's a husband and wife and they owned a house together, let's say the wife died before the husband, now just the husband owns the house. They do not have to do a new deed to take her name off of it. If you own a house, a real estate with a deceased person, you own that house. You don't have to do a new deed to take their name off of it. You now own the whole thing. So you can now transfer that. It's called a fiduciary deed. It is a deed, basically says, I'm just the executor or the administrator of the estate. I have not lived in that house for many years. I don't have a lot of firsthand knowledge about it. I'm just the executor. It's not really my personal house, so I can't really warrant too much about it. You're going to have to look on your own to get it inspected and make sure that everything's taken care of. That's called a fiduciary deed. In Florida, it's called a personal representative deed. Same thing. It's that type of deed that's transferring the property. If the executor wants the house for themselves, they're required to go to court and ask the court for the okay to transfer the home to the property to them. And they got the other heirs got to agree to that. That's the idea behind that is don't let the executor, railroad people by taking something and trying to get a better deal on it. That's why they have to go to the court to do that. Not a warranty deed. It's a fiduciary, not a warranty. And then you settle the house, settle the estate, and this is kind of a big deal. You're closing it up. You don't want anybody coming back and suing you later on and saying you didn't do a good job. I want an accounting. I want this. I want that. You took too much money. Sometimes people forget this gets funny that way. So you want some finalization to this for yourself. You can do a family settlement agreement, which is my preferred way. That's a contract, usually 2 pages long, that says, I finished the estate. I've given you notice of everything. I've done everything I'm supposed to do. This is what came in. This is what went out. This is how much you got. And you are happy with it, and you accept your money. And if I missed anything, and you're required to pay part of it back, you will pay part of it back. You won't sue us. We're done. That's a release. So we do those. Sometimes it's so small that there's no need for all that. Like if somebody's given $10,000 and you pay them $10,000, you don't need to do a fancy settlement contract for that. You just say, You sign this receipt, I've received my $10,000 and I release the executor from anything further. Or you go to court for a full-blown accounting. That's recommended where there's just a lot of problems. You want to have the court say, you know, when they go to court, what happens is you give notice to everybody, especially the ones that are going to be potential troublemakers. It's like, speak now or forever hold your peace. You got a day in court. I'm going to file this paperwork. If you have an objection, you got to come to court and object to it. If they don't, it's done. Okay. Timing looks good. And then the final thing is, when everything's done, within 2 years of having opened the estate, you have to file a status report. And it says, is the administration done, yes or no? If it's not done, how much more time do you think it will take? And and if it is, did you give an informal accounting or a formal accounting to the heirs? And that's the closing of the estate. Pretty good time.
Yeah.
So I've covered a lot. Any questions here, there?
Well, let's, if we don't mind, there's 2 questions in the chat. And then we'll take the questions in here. Will slides be available? Yes, the slides will be available. We'll be emailing them out to everybody. Sounds great. That's really it. So yes, any questions in here?
I just have one quick note here for all the people that are on Zoom. I'm gonna put a quick poll up on the screen for some demographic questions. If everyone that's joining us virtually could please fill that out. Will anybody else ask any questions? That'd be excellent. Thank you so much.
The executor most take no money for all, but those that do typically take. Strikes me as long as it's $1 million versus like $1,000. Percentage or
Yeah, so I'll just repeat it for everybody who's listening. He said it strikes him as odd that it's a percentage when there's a big difference between a $20 million estate and a $200,000 estate. Well, it's not. It's a reduced scale percentage. So it might start out at 5% for the first 100,000, 4% for the next 100,000, 3% up to $1 million, 1% from $1 million to $2 million, and then 0.5% for every million after that. So it goes down. So it's not ridiculous.
And that's a lot easier than the executor trying to keep track
Well, yeah. Technically, that's just keeping your time is a lot of work.
Yeah.
But it's called presumed reasonable. So if it's a 3% and the executive charges 3%, then if they get a quarter of that, that's presumed to be reasonable. That's 3% of the estate. It's okay. You have to give some idea. You have to say reasons why that's too much. Why they shouldn't take that much. So the burden, the onus, is on the objector. If it's under the presumed reasonable amount of 3% in my example.
Earlier you said about the $20 million estate, you said an example, the kids got 1% and the wife got 1%. I was told in the past that in Pennsylvania, the spouse inherits everything. That's not the case.
No, it's not the case. He was told in the past that in Pennsylvania the spouse inherits everything. No. Well, but as a practical matter, most married couples have everything joint. The house is joint.
So minor children can inherit part of it?
Minor children, I didn't even get into that.
Okay.
If you're under 18, you've got to go to court. If there's nobody, most wills done properly for somebody that has minor children, they're going to say that there will be a guardian of the estate in the person of any minor children under the age of 18. And so it will go actually to the guardian that they name in that will to hold their money until they're 18. If you're under 18, 18 or under 18, you cannot inherit money from an estate.
I have one question. What about safe deposit boxes?
The bane of my existence. Safe deposit boxes. You have to go through a process to get access to the safe deposit box. You got to send notification to the state that this person died. They have a safe deposit box that's at this bank. You have to notify the bank that you're coming in on this date with this, to inventory the safe deposit box. Then you have to show up at the bank with the executor and this inventory sheet, and you have to fill out this form that says whose name is it on, who's the last person to enter, when did they enter, when did they open the box, and what was in the box, every single thing. And the reason that they do that, in part, is they don't want you hiding any money. No kidding. I had a safe deposit box, had $208,000 in cash. It was a big box. But if they could just go in there, get that money, the state wouldn't know, and they wouldn't have got their inheritance tax money. So that was just, there was an interesting point about that story too. There's 3 children, and one of the guys said to me, he says, "Yeah, well, I got like almost $70,000 here. How am I gonna get that home?" He says, "I'm not gonna put it in my suitcase." He said, "I'm not gonna take it to carry on at the airport." So yeah, it's a problem.
Big problem to have. Is there inheritance tax on gifts?
Yeah. Gifts made within 1 year of death are called gifts made in contemplation of death. And so if it's if the person died within 1 year from the date of the gift, that is subject to inheritance tax.
If the descendant owns no real estate and only has a small savings account, must an estate be probated? The descendant has a will dividing the asset among all of her children.
Title 20, Section 3101. This is a really good section to know. I'm not showing off. I say that because you would actually want to write this one down if you have a situation. If when somebody dies, all they have is a small bank account with $10,000 or less in it, you can take a copy of the paid funeral bill to the bank with a death certificate, and they are allowed to give you that money. It's still subject to tax, and it's still subject to be distributed to the heirs according to the terms of the will, but that's too much hassle for an account that small. But they want to make sure that funeral director is paid first. So you have to get proof. If you haven't paid, say, well, we need this money to pay the funeral director, and you bring the funeral director's bill in, they'll pay that to the funeral director, and they give you the rest of it. But frankly, there's a lot of banks, tellers of banks, that aren't aware of this little law out there. Title 20, Section 3101. Yeah.
If you have one child who's on the will, you still gotta pay an executor through your probate.
If you have one child is in your will, you still have to pay an executor. Most times executors don't want to be paid because they've got to record that as income on their income tax return.
Well, I didn't mean paid, I mean, you still gotta go through the process. Does he have to be an executor? Does he have to go through probate? If you have a home, you still gotta go through that.
If you have a home that's in your name, will or no will, to get that home into anybody else's name or to sell it, it's got to go through probate. There are ways around it. I'm not going to get into a lot of estate planning, but I've done a lot of it. You can do a will with what's called a life estate deed. And it's a deed to your house. I give my house to my children, but I reserve the rights to everything until I pass away. I'm in charge of the taxes, the maintenance, insurance. I can rent it if I want so much. But when I die, by virtue of this deed, right to my children. So you don't have to probate that. They still pay inheritance taxes on it, but you don't have to probate it. It goes right to the children automatically. You cannot sell that house without their okay once you do that deed. And this is I should put this in for the next presentation. So many people, I do a radio show with KDK. Did you guys ever hear this show? A couple, yeah. So I threw it out there once. I said, somebody called about, well, I told my kids I want to put my house into their names. Is that a good idea? I said, no, it's a bad idea. The lines lit up after that. I don't talk about that every week because I like having lots of callers. But why is that a bad idea? So there's 2 taxes. There's inheritance taxes or there's capital gains taxes. And if you die and your children inherit, they pay 4.5% of the full value of the house. But their basis for purposes of calculating these capital gains is the fair market value at date of death. What do you sell it for? It's a $200,000 house. We sold it for $200,000. Boom. Inheritance taxes, there's no gain because my basis went up. Mom paid $40,000 for it when she got it. If she gives it to me, my basis is $40,000. It's not my home, so it's not exempt from capital gains taxes. If I then sell it after she's passed away, yeah, maybe I didn't pay any inheritance taxes, but it wasn't probate, it wasn't inheritance taxable, and my basis was not stepped up. So my basis is $40,000. I sell for $200,000. I have $160,000 gain, and my tax is 20% of that. $32,000 versus $9,000 for inheritance. And most people are not aware of that until January, the year after they sold the house, comes around, they spend all the money, did everything, and they get a 1099 in the mail. They give it to their CPA, they say, what's this? The CPA has to break it to, you've got a capital gains tax here. So that wasn't my house, that was Mom's house. No, that was actually your house. I mean, when she put your name onto it, that means that you own it. I think I should kind of put that in there.
We'll add that next time. Any other questions?
Well, my cousin, he had some money in IRA. I don't think it's a whole lot. He died a few years ago. The lawyer I deal with, they said, hey, because of that money in that, good about getting that money because nobody knew about it. He never had a probate, never owned a home. And that money's with that company now, and I don't know how long before they turn it into the state. Is there a way going about seeing how much?
He had no will.
He had no will.
That's intestate. Was he married? Did he have children?
No.
You gotta follow, you gotta talk to the lawyer about tracing that tree down. It's gonna be brothers and sisters next.
He got one brother. Did his brother find out if there was money there, and how would he go about doing it?
Well, he's gonna have to,
He died about maybe 3 years ago, 4 years ago.
his brother will have to try to find out from the company what it's worth, but in any event, he's probably got to open up an estate. He might ask the company, look, I need to open up an estate. If it's under $35,000, I can go this route. If it's more than that, can you just tell me they're worth more or less than $35,000? Maybe they'll tell you. And even when it does go to the state, it goes to unclaimed property. So he can still get it to unclaimed property. It's not like it goes to the state and it's gone.
Is that a website you can look on unclaimed property?
You do Google search on Pennsylvania unclaimed property. It'll take you to the treasuries, Pennsylvania Treasury. You put your own name in. When I left Florida, I put my name in Florida. I had $67 at Florida Power and Light and escrowed away from me. This is kind of fun.
That is fun.
Yeah.
Well, thank you, everybody. Oh, sorry. Yes, absolutely.
Yes. So the house is in a living trust. You won't have to probate it, but you will have to pay inheritance taxes on it. You get the step up. You'll inherit it through the living trust. If it's a revocable living trust, like I'm thinking of, typical.
You guys did it.
Oh, that'd be fantastic.
Nice one.
Here's a plant. Okay.
No, but we'll send it to you. We have your contact information.
Did you sign up?
I have your info. Yeah.
Oh, I gotcha. Oh, okay. You know what? I'll print it out for you. Right after this is done. I don't know. I'll print it out.
You just don't forget at Christmas time to make a charitable donation to the library.
I also wanted to share this slide that's up there. These are just some of the programs that are going to be coming in the next few weeks. We have a landlord tenant one on the 28th. We have court basics on the 4th, family court on the 5th. Another how to administer an estate on the, what does that say, the 23rd? And then landlord tenant again. And you can follow us on at our website, on our social media. And as I mentioned, we'll share all of this presentation with you. And you can actually go onto our website, pmconline.org, and see all the videos of all the previous workshops, which is very, very helpful. Thank you, Carl.
Thank you.